Is it close enough to 1:30? Everybody ready to start? Okay, let's kick it off. Welcome everyone to our meeting. Thank everyone for showing up and coming in and your interest in this. I would begin by saying I would like to have been a little bit further down the road than we are today, but maybe we'll get there. We got, I think, 4 different responses or inputs, I'll suggest. 2 from Trace, 1 from Mr. Campbell, and 1 from Mark Salmon, right? I'd like to go and let those 3 gentlemen tell us what they've got, and then we'll discuss those from there. Is that all right? Trace, you got 2. Go ahead.
Yes, sir. And I actually brought copies if you...
That even, yeah, pass those out, if you don't mind.
Let's go that way.
You got a copy?
Yes, sir. So...
Oh. You got one, Taylor?
That's a copy of our second draft, which is what I'll be focusing on and kind of talking about. The first draft that we submitted was simply follows SB 264 and makes slight changes to SB 264, just kind of as Senator Albritton had discussed at the last meeting. But the second draft contains significant changes, and it is what we would like to work on or to propose. So just working through it.
So make clear then, so you really have only one to discuss then?
Yes, sir.
Okay, then we'll, good enough. That makes it easier. All right. We're on AGC draft 2 then.
Yes, sir. And I'll just go kind of point out exactly what has changed in this draft as compared to others, and then we'll explain why we made those changes. So everything that's underlined is a change that we have proposed. So the synopsis, just kind of shortening the synopsis and making it more consistent with the bill. We've taken out the section 1 from SB 264, the legislative intent section, and just begun with the definitions. Under the definition of party in section 1, we have changed private business to business entity as to avoid any ambiguity that may exist that would exempt public corporations from the bill. By saying private business, that there was concern on our part that public corporations may be able to claim an exemption. Section 2, and let me also stop and say that the way that this bill is laid out, it's a more concise layout where the subject matters, you'll see there's an A and a B section, and it's kind of to combine the subject matters, and it's actually follows the drafting that was in the architects and design professionals bill. And so it's just to cut down on the amount of code sections that would be added if this bill were to pass. And so I think the previous bill, 264, had, I believe it was 9 new sections to the Alabama code is what it would be adding. This one is simply adding 4. So section 2A, there's some changes there in regards to the contain a provision clause, covenant, or agreement. And then we've also changed under the arise out of, result from, or caused by instead of just caused by. And then you'll see the very last sentence to that paragraph is new, and that's to limit the indemnity requirements an upstream party can require of a downstream party, as we discussed that in the commission meetings. Section 2B is a lot like the section 4 from the previous bill, and instead of it basically is just changed to make explicitly clear what can be allowed. Let's see. Section 2C, that's the severability clause of the legislation, and we added that to basically for the courts. And so there's a court wouldn't void the contract as a whole, but would simply void that portion of the contract while allowing the rest of the contract to stand. And then section 3 is all of section 5, 6, 7, and 8 of SB 264. Again, it's just combining those sections into one because each of those sections said what the bill doesn't apply to. And so instead of having multiple new sections, we just started with one phrase that says nothing. This act shall not be interpreted or construed to affect the following, and then went down the line from the previous sections in 264. It does contain, you'll see on 5 and 6, there's specific language stating that it does not apply to design professionals or the road builders. And then the last one is section 4, and that's the effective date. And we thought instead of making it immediately effective, extending the time frame to allow parties to educate themselves on the law and to revise their contracts would be better and helpful. And so what we are proposing essentially is that we change the language of 264 that uses to the extent of a party's negligence to simply use sole negligence. So a party cannot require another party to indemnify them for their sole negligence or intentional misconduct and so on and so forth. We believe that sole negligence follows with both Alabama tort law and Alabama case law. Actually, there's a Supreme Court opinion as well as 11th Circuit that addressed an indemnification agreement on that used the language to the extent. And in that opinion, the court said that to the extent is ambiguous, and the court was unable to weigh in as to what that meant and that it would have to go to a jury. And so if to the extent was used in this bill, really you can foresee where any disputes over the indemnity agreement would be something that goes to a jury, and that just drags everything out, adds money, time consuming, and sole negligence is also used by 15 other states as provided under the LSA memo. It's also used by the other 2 contributory negligence states that have anti-indemnity legislation. So there are 4 states that have contributory negligence as their tort law. 2 of them have anti-indemnity statutes, and both of them use sole negligence. Sole negligence also follows the contract template that is provided by the Division of Construction Management under the Department of Finance. It follows the language under the DOC prison contract, and also again follows the 2 other contributory negligence states.
Thank you, Joyce. Appreciate that.
Yes, sir.
Mr. Campbell? I don't even have a copy of it. Did I get it? I don't remember. I hope you didn't use the ATT email. Okay. We'll get copies of that, and we'll hold off on that, and we'll go to Mr. Salmon and let him go, and then we'll have yours in hand, and we can talk about that. Mr. Salmon, how are you?
Senator, I'm doing well.
We have a letter, I think, from you. Is that what we got?
We do.
All right. Do we have copies for everybody?
We do not.
It is in that this is not a proposal, as far as a legislative act. How about just tell us what you wrote to us?
In brief here, let me just state what we proposed. In summary, I'll get to the last page instead of the previous two that are on the beginning of this. When we looked at this, we really feel like that this is an issue between the general contractors and subcontractors. And so let me read what we've got so that you can understand what our position is. Because the issue we feel is between general contractors and subcontractors and should remain that way without impacting project contracts for owners. Our primary recommendation is to eliminate consideration of SB 264 or similar legislation and instead consider amending Alabama Code 34-8-1 to make this an issue of the general contractor licensing. No public policy carve-out would be needed, and these changes would not affect owners nor affect the freedom to contract directly. Such a mandatory language would hold that in order to obtain a GC license, the GC cannot require subcontractors to indemnify the GC for the GC's sole negligence and vice versa. Any such contract would not be void, but GCs found in violation of the General Contractors Licensing Board could be subject to fines or lose any of its licensure. The licensure board could also develop rules that would balance tests to protect progressive negligent parties. Our thought was that perhaps this needs to go back and be part of the licensing board, and if that is not favorable to the general contractors, perhaps there's another way to manage and provide oversight to this. But our position is this is between the GCs and the subcontractors. Let me read on further. However, should the majority of the study commission members wish to move forward with legislation similar to SB 264 as the vehicle for addressing this issue, the ACCS proposes exclusion of public owners from all definitions and provisions to alleviate our concerns with the legislation. To accomplish this, we propose the following language modifications to definition in SB 264. 1. Construction contract. A contract, subcontract, purchase order, or any agreement for the planning, management, construction, supply, repair, reconstruction, replacement, rehabilitation, or improvement of a multi-family residential and commercial construction project in the state. And 2. The party. This definition would be amended to read, an individual or business that is a party to a construction contract. This act shall not apply to any local or government entity as a party to a construction contract.
Basically, is a carve-out exclusionary.
It is.
For the state or a government entity. Is that accurate?
Yes, sir.
That, Trace, just to go back, did you had that in your proposal under the parties, is that correct? Or no, on the first page, you simply an individual or business entity, correct?
Yes, sir. We just amended that to remove private business. We did not do anything with regards to public. Now, that being said, we did not amend. I think really the gist of it comes under number 1 in construction contract, not actually under party. And under construction contract, it says currently and under the GC licensing, which is where this came from, improvement of any private or public construction contract. And what he was proposing from ACCS is to remove the or public.
Thank you for that clarification. Mr. Campbell, we're getting them, but if you want to go ahead and kick it off, I'll give you the floor. Probably a mistake, but
One with trades, we've got some exclusions here. Some things that are interesting is you know, obviously we've discussed before the salt language, and it was discussed last meeting how that's really somewhat of a misnomer because therefore, what would happen would be that if you don't get there, so the party's still responsible if you don't find out the salt language. Trey, I've got a question as to the next sentence that's underlined, furthermore, the indemnification obligations of a subcontractor shall not be broader than the indemnification of obligations contained in the contract. One of the things that I've heard from both variations. Yeah, I'm sorry. Yeah, is that better? Sorry. One thing that I haven't heard from both variations is that one of the groups are the suppliers to a very large degree. They have pushed this just as hard as we have, the concrete individuals and anything else. This does not seem to address that it shouldn't be broader. Really, the reality is it should never be broader than a sub of a sub, or even the suppliers. It's not, unfortunately, it's not just a general contractor, subcontractor issue. It is also material men and supplier issues, and I want to make and clarify that. Go ahead, I'm sorry.
No, totally understand where you're coming from, and I'll say this language is unique. We didn't find it in any other states, and we would be open to amending it to what you're discussing right now. It was not intended in any way to limit only to subs and to cut out suppliers. So if we want to look at this language and amending it or changing it, that's fine with us.
The other thing is that you already, again, we've got to, you know, recognize that we already have two statutes. While we can talk about some cases and things of that nature, the language in these statutes exist, and these statutes do exist both for road builders public and for architects and engineers on both public and private works. We have an issue that I don't believe the architects and engineers are aware of. While the architects and engineers are protected from design, many of the architects and engineers also do things outside the design. They do some project management, they do some work, and they are not protected in any way, sense, or form. So if they are of the understanding or of the belief that they are protected from having to indemnify somebody for their complete sole negligence, they're mistaken, because they do things outside of it. It just protects the design aspect, and I would, you know, be wary of looking at that. Going to deal with the things from the General Contractors Licensor Board is problematic because of material men, suppliers who may not fall under that. Again, we also have two statutes that address that as well, so I don't believe that would be the proper avenue for that. But if everybody has a copy.
We do, I think, all up
Okay,
here,
so
handed out now.
I'd rather go to that. So basically, I'm sorry, Anthony, did you just provide the copy, not the issue summary, correct, to everybody? Okay, that's okay. That's no problem. So what I did is, you know, with your request, Senator Albritton, I, you know, followed what we had. And basically what I did to change some things here is Section 1 really remains the same. It's the best interest the state realizes of private businesses or individuals entering into a construction contract, financially responsible. I go into that in the indemnifying party, and it says, you know, the contract cannot allow language that requires one party to indemnify another, the contract language, for their own negligence. Now, we have our Section 2, which has 1 and 2, which has your definitions of the construction contract and party. I'm in agreement with Trey on the party that we can change that definition. That was only used because that's in existing statute, so I followed that. But private business entity would be fine for doing that, because that would include public and private. As you're aware, we have public for the road builders right now. As I understand, they will be introducing some legislation next session to include private, so it won't just be public and private, and you also have architects and engineers with public and private. So Section 3, this is where I go into the specifics here. Again, I want to explain that we have no problem as subcontractors and material men. I would also say that I'm able to speak. Carrick Wisenhunt for ABC North Alabama was not able to make it, but he and I did talk, and he said that I was able to speak on his behalf, and they supported what I provided here, and they would be in support of that. But it just says, hey, look, we're not going to have the contract requiring the indemnification, the hold harmless, defend others for their own negligence, intentional misconduct of the party, indemnified officers, employees, or agents. Any such requirement contained in the contract entered into after the effective date of this act is against public policy, void, and wholly unenforceable. We have no problem with extending that date and the time, as Trey had said, for some to give, to maybe readjust the contracts or anything of that nature. That's not a big issue. But Section 4, we go ahead and tell, here's what I want to be clear about. Again, the only thing that we have requested, and the material men and suppliers and concrete industry has requested as well, is we do not want to have to potentially lose our jobs, to lose our companies, and to lose our houses or anything else, indemnifying for somebody else for their own negligence. That is not a contract, that is an insurance policy. Essentially, that is saying that just because you have a contract with me, you're going to insure me for anything that I do. We don't want to lose our businesses. We don't want to lose our family homes or anything of that nature. To the extent that it is covered by insurance and there are insurance products, which we have discussed before, that will cover everybody for their own negligence and for somebody else's that are available, we say, look, a construction contract may contain a provision requiring a party to the contract to indemnify, hold harmless, or defend another party, but only to the extent, and again, we can change that language for extent from extent, but that was in the statutes, and that's why we used it as well. The liability, wantonness, intentional of the indemnifying party or the indemnifying party's officers, employees, or agents. Section 5, being the important one, allows for the insurance. This allows for the loophole which does not exist in the statute for the road builders or the statute for the architects and engineers. It says Section 3 and Section 4 shall not apply to construction bonds, contracts of insurance, or insurance policies that provide for the defense, indemnification, or holding harmless of a party or contract clauses regarding insurance. Section 3 and Section 4 are intended only to affect the contractual relationship between the parties relating to the defense, indemnification, or holding harmless of a party, and nothing in this section shall affect any other rights or remedies of the contracting parties. And then it just talks about the effective date becoming immediate upon passage. So really what we're trying to make clear, and the difference that we have here is, one, public already exists, public and private already exist. We don't want winners and losers. We do want individuals to be responsible for their own actions. Under the present language or the lack of a present statute, an individual may be completely responsible for an OSHA violation for the death of an individual, but have no fiscal financial liability whatsoever by putting it upon other individuals who may have not been anything other than on the premises or had a contract because of contract language. So that is where we are going to differ from the other parties there. Again, we do not have a problem indemnifying others for their own negligence to the extent covered by insurance. We don't have a problem paying for insurance that would cover that and the different insurance products that have that, but we do have a problem of potentially losing our businesses and our homes.
Thank you for that. I now invite comments from the other members. Sure.
No, it is subcontractors, everybody, and we can adjust this accordingly, as I did with the, I think you've seen the previous one that Lister had done a draft previously, and that didn't even include generals. This is intended to include generals, subs of subs, material men, suppliers, all of them. So the way that this is written is, this is the job of the GC, the subs, and everybody underneath them. You are responsible. So the intent here is you can either purchase an OSIP, a CSIP, a builder's risk, or something that for a general contractor who doesn't want to be, or an owner. Yes. The general contractor is not. It is not for the defense or the indemnification or the hold harmless of the subs for their acts. They would only be responsible and only held responsible to the extent that they are pulled in. Again, we don't, Oscar, you're aware that we rarely get to the final breakdown of what that is. But no, everyone, the bottom line is everybody should be responsible for their own actions in the defense and indemnity. And again, to the extent that insurance covers it, a sub can be responsible or a general to an owner. I would have to actually see it. I don't feel comfortable answering. I don't believe that I would, but I do need to see it written out and how it's actually done before I would be able to give you a firm. Yeah.
You would invite some additional language for your review. Is that accurate?
I never mind additional language. As a matter of the only thing that I asked for from the beginning is if you can protect us from losing our homes and our potentially homes and business, then I'm okay.
All right. Yes, sir.
Senator, I'm Ben Baker with the Alabama Association for Justice. Our association and I was personally involved in putting together the architect statute and the road builder statute. Substantively, we don't really have an issue with anything that's going on with either of these proposals, except we had 3 issues that we were concerned about that were put in the architects and the road builders bill. And in your bill, SB 264, those issues are covered in Section 7 and Section 8 related to joint and several liability, third-party tort claims, and workers' compensation laws. Those are in Trace's proposal. They are not in Mr. Campbell's proposal. So to the extent any of these would be adopted, we would ask that those sections be included.
And then we've discussed that, and that I had agreed. The only reason why I did not put that in, and I told Justin as well, was I did not want to necessarily confuse the issues, but it has always been understood that what the Association of Justice wanted would be included in that.
All right. We have an agreement on that, at least. Any other comments? Yes, sir.
Yeah. So, David, I'm I'm trying to think through the practicality of how you would actually insure this. So, if I'm understanding it, you're saying that you want any obligation to defend, indemnify, and hold harmless that might be contained in the contract to be against public policy as one premise. However, if it's insured to the extent of the insurance, it's okay to do.
To clarify it, I don't want to see in a contract, in any contract that we have, that do not want to see in the contract where it says that one shall indemnify another for their own negligence, defend or indemnify another for their own negligence for what they've done. That does not mean that you cannot have in that contract requirements for insurance, requirements for an OSIP, a requirement for additional insured, which would protect to that extent. The problem that occurs is that in these contracts, the specific language that it says is, it says it doesn't matter whether it's insured or not, right? So all I'm wanting to do, and again, if there's any language that's suggested otherwise, to the extent that it's covered by insurance, we'll do it. To the extent that we're an additional insured, we'll do it. To the extent that there's an OSIP, but I do not want to see in the contract, even if it said in the contract, I wouldn't have a problem if the contract said to the extent of insurance. It's just when it goes above and beyond that.
Yeah, so I think we're talking kind of about apples and oranges, maybe, and I understand where you're trying to go with it. I think the way it's written here, we're problematic for a couple of reasons. One is if you statutorily say that having a duty or an obligation to defend, indemnify, and hold harmless is against public policy, you're not going to be able to insure it because it's against public policy.
And I'm not saying it as broadly as you're saying that. I mean,
that's kind of the way it reads.
And we can
Yeah.
we can
Not
go ahead.
arguing.
Right. Yeah. That is right.
Okay.
That the wordsmith aspect, that is not the intent. The intent is for another's own negligence there.
Trying to point out
Yeah.
some of the potential problems that you would run into further down the road. Secondly, the insurance, to the extent you have insurance, is going to be triggered by the contract. So you can have 100 different additional insured endorsements, but if you don't have an obligation and a duty that's triggered by the contract, you don't have anything. The carrier's going to say, bye-bye, we ain't playing. So you have to have language, and I think what you're trying to do, and please correct correct me if I'm wrong, I think you're trying to say that you want to have this duty and obligation to defend, indemnify, and hold harmless, except for the sole negligence. I agree that should go away. But anyway, you have some duty to defend, indemnify, and hold harmless, which is limited to the extent of the contract or of the insurance. It's limited to the amount and sufficiency of the insurance. So if the GC wants to say, we think that the roofing contractor is going to be exposed to $5 million. We're going to require them to have $5 million. They pay out $5 million to defend, indemnify, and hold us harmless. They're done. That's it. That's one provision. Whereas the structural steel guy might need to have $25 million.
And absolutely, to the extent that you can wordsmith that better, that was a little difficult because I was trying to do away with, obviously, to still allow for the insured, that loophole to provide that. Again, the only intent from the, and I'll reiterate it again, is just to protect these individuals from potentially
Personal liability.
For someone else's negligence. Correct. And in any manner that we can do that, I would be happy to see that.
Senator,
Yes, sir.
I would just like to ask Mr. Campbell, and I know other parties have asked this throughout our meetings, but how often is someone actually personally liable for these actions? I mean, if like you said, I think you listed off 6 different types of insurance you can get on a project, as well as, your liability, personal liability shields through LLC or corporations and things like that. I think we would agree that no one should lose their livelihood or their business, but how often is this actually happening?
Every single time, because you have to pay deductibles, you have time, you have to go ahead and pay attorneys. If you don't have to, your company may have to hire their own attorney as well, outside of what's covered by insurance, the time that it takes for the individuals to be deposed and everything else. So it does cost them personally every single time. If you're asking how often do they lose their businesses or their livelihood, I'm not aware of how often that may occur.
I can jump in a little bit on that. It's a rarity because they're going to bankrupt out. That's the course of action. But it does happen, and it happens more. The Brassfield and Gories of the world, the Horrors of the world, they're not going to hire Bob and his truck to go out and do something, right? But Bob and his truck is also going to be affected by this legislation. And those people may well be impacted much more severely. So it's a rarity that it really happens, but bankruptcy is the alternative.
So would Bob and his truck not apply if we increase the monetary threshold in which this applies to 100,000, 150? I mean,
not really. I mean, I don't know, what's the number, right? So I don't know that's the solution as much as one requiring insurance. Bob and his truck should have insurance. But, again, people go out and contract and make a living and do what they have to do as best they can. I think we're really trying to talk about the mainstream business that's conducted here. And what are those protections? So we don't want a whole bunch of people to run out and have to go bankrupt either, right? So I think we're pretty close with an intent. I mean, with what David has said as that groundwork, where he's not opposed to having to defend, indemnify, and hold harmless the GCs, as long as there's a limitation in insurance. Now we're just talking about making sure that we have the right triggers of coverage and the right policies in place.
Absolutely. That's what we're looking for. We're not looking for anything more than that. And again, somebody may be much better wordsmithing at that to create that.
The last thing I'll say is, our goal should be to draft something that is consistent with current law, and also that is something that's workable under both Alabama statutes and case law. And the sole negligence provisions are what is consistent with the contributory negligence, as well as, I think you said it was a misnomer, but 15 other states have it. And Alabama, again, there's been a Alabama Supreme Court and 11th Circuit opinion that says to the extent is ambiguous, and it'll have to go to the jury to work those out. And so I think the sole negligence is what fits under Alabama law right now.
I'm interested, gentlemen, in addressing briefly the questions of exclusion that's been brought by the ACCS. Any comments or thoughts along that line?
Yes. Senator, I don't think if we got to a point in the bill that we were supportive of, and the sole negligence, I think I actually heard Mark say the sole negligence is what they have already in their contracts. And if we got to a point where that's what was in the bill, I don't think we would have a problem excluding public corporation or public entities, state and local entities from the bill.
Yes, sir.
Ryan Hollingsworth of school superintendents, and we fully support their position, been involved with discussions prior to this meeting. So I am a little, our concern and our contracts are with the GCs, and that's who we work with. We don't work with the 47 subs that they hire. And so some of the conversation going on here about GC not being responsible, I'm a little concerned about some of that, but we do support his position.
Any other comments? Yes, sir.
We do have two statutes here now that address public. So you're talking about a carve out now of
Right.
of
That's why I'm bringing it up.
So that is going to be somewhat difficult. I do have a question for you, just real quickly. The sole being in there, as long as in how you view this language coming up, with that limit and being able to do that with some type of cap, some type of insurance, does the sole bother you at that point if you're able to?
Well,
to address it?
you wouldn't have a limit on the sole. You would do away with the sole. Yeah,
Correct.
in its entirety. So the rest of it, I mean, it all works like it's written really now. I mean, if you're a sub and you are in privity with your GC, you're ultimately responsible. Forget about insurance. Insurance doesn't matter. Insurance is just a funding mechanism. It's all about who's responsible for which parties. And so you hire your sub, which is a sub to the GC, and they do something, you're still responsible. So that GC is going to hold you responsible for that. And the owner is going to hold the GC responsible. And it's all going to flow downhill. And where the problem comes in my real world experience, is as it flows down to the lowest common denominator, they don't have the coverage, they don't have the money, they go bankrupt, they're done. And so you have a lot of litigation going upstream, trying to trigger everybody's policies. And it seems to make sense if you can wordsmith it where there's some type of a limitation. You don't change the obligation. Alabama statutes are Alabama statutes, and the negligence is going to attach the way the negligence attaches, and consistent with all the court rulings that we have. And any of that changes. The only thing that I hear you trying to propose, and I may be wrong, is on the back end there be some finite limitation as to what that dollar amount is relative to the contract that you've signed.
Correct. I mean, again, with the assumption that you're able to.
None of this applies to third parties because you can't affect that anyway.
Correct. Yeah. No, you're absolutely right.
Any other questions, comments, discussions? Yes, sir.
Senator, yes, I'm Riley Roby, attorney on behalf of the Alabama Concrete Industries Association. If I could for Trace, I was interested in the in your draft 2 language, section 2A, the limiting sentence that you added at the end seems to just limit it, if you will, to situations. It limits it to whatever the GC may be obligated for under his contract with the owner. Would there be openness to, limiting that more to just the scope of the underlying contract itself, such that the GC could not impose on the sub responsibility that expands beyond what the sub's actual contract for the GC is there to do?
Honestly, not sure exactly what you're asking of me. I think
So if I could, just by maybe way of example, let's assume a situation where you're the project owner and you hire a GC to do any and everything under the sun for you with a building of some sort. And I've got a guy supplying concrete for the project, for the foundation. And there's an injury that occurs as a result of something that arguably either the GC or a roofing contractor did. But the GC's contract with the owner says that the GC is responsible to the owner for any and everything under the sun to insulate that owner from any potential liability. So your language, as I interpreted as it was added, could enable the GC to simply pass that same broad liability responsibility onto the sub. And I wonder if there's a way that we could consider language that would limit that sub's responsibility on an indemnity obligation to just what it is that the sub is responsible for doing for the general on that particular contract.
Yeah, I think we'd be open to any type of language revisions that you may suggest. And with the example that you gave, it was not the intent that, anything and everything under the sun and that flow down. It was more so because if you have the sole negligence that you're not liable to that, then say that the GC has an indemnity agreement with the owner that has a monetary threshold or it has different language as opposed to the sole, and it's that the GC couldn't then go to downstream parties and put in sole negligence or something that was broader than what he is. And so if there's language that you're thinking of or that you would like to propose in terms of a downstream limitation, I think we'd be open to reviewing that, definitely. And again, we didn't mean to just limit it to subcontractors and not suppliers or anything like that. This language is unique. We didn't find it didn't come from any other state statutes or anything, but it was a way that we thought would maybe make it more palatable to those downstream contractors, and just using subcontractor as opposed to supplier or anything else is just simple oversight. So if there's limiting language or additional language you'd like to propose, we definitely consider it.
So, certainly.
We have members that are owners, contractors, subcontractors. We even let lawyers do that. Well, in our membership,
Foolish, I would say.
we have members who are very much in favor of David's concept. Very, very vocal, very strong feel about that. We also have members that are very opposed to David's statute. So for that reason, ABC Alabama is not taking a position on this bill. We're not supporting, we're not opposing it. But one thing that our membership does feel very strongly about is that we ought to do something. And something is better than nothing. The best we can get is eliminating sole negligence, especially if we throw in there limiting the downstream liability. We would rather have that than nothing. Okay, and so we don't want to see it all die because we can't agree over excluding to the extent. And I appreciate this is the first time I've heard that y'all been willing to let the insurance and cover what's been the comparative.
I apologize because that's been from very day one when we introduced the bill. So and I'm sorry that you don't know that, but that was always within the negotiations. Oscar, do you? No, and it didn't at the time. It was known that we had to introduce it because it was the same bill as the road builders. It was the easiest way to do that, with the understanding, in the same way that Ben and I have an understanding in the justice that we're going to put that in. It won't go forward without that. So that is the understanding. Do you see, Oscar, anything based upon this no broader language and being able to put a limit, like it's been suggested, some type of monetary limit to allow that so the downflow can get the insurance necessary? Do you see that as a possibility of? No, and I mean in concept. No,
We can have language so that the insurance, the subs, let's take an example, the subs insurance policy covers everybody to the limits of those insurance. That's what you're saying. That's different than what I've been understanding.
yeah. Now I'll say it one more time for everybody, so it's very clear from here on out. We do not have our members don't, and I've talked with Concrete, do not have a problem with that loophole, the additional insured loophole, from the standpoint that another's negligence is covered by insurance. The only thing that we were looking at, the only thing that we want to do is protect the businesses. Those who don't have an LLC can do bankruptcy. An individual business can lose homes and everything else. To the extent that there's insurance that covers that, we understand that. And we understand that while many states have something, they do allow for that additional insured loophole. So we have never intended to completely close the additional insured loophole like the road builders and like the architects and engineers.
That's why we have you guys here. Okay? No, that's why we have you here. Now, if I might, if there's any more discussions, we'll get back to that in just a minute. But what I'd like to do, it sounds like we're headed in an appropriate direction. We've had several good comments, and we've got, I think, 4 to 5 folks that want to have language input on this. Am I accurate on this? Now, Oscar, I know you don't want to claim anything, but if you could assist in getting the language that we need to make sure we get done what needs to be done, make sure we get the lawyerly language involved, make sure we get what else was there, the discussion going in. Let's get that together. And then the other aspect is let's decide amongst us, what are we going to do with the exclusions in the government, the schools? Okay? And let's put something together pretty quickly. I'll tell y'all are highly paid guys. I'm only a part-time dude, okay? Y'all don't need to be spending your time here. I want to have maybe one more meeting, and that should be October. I'd like to have this language starting to be interchanged this evening, if we could, so that we can move forward. I'd like within 10 days, and David, I'm going to jump to you here. Within 10 days, I want to have the language that we're talking about. It doesn't have to be agreed to or anything else. I'm not asking for consensus in 10 days, but I'm asking for the additional language that may provide, whether it deal with the sole negligence issue, whether it deal with the protections and limitations. All of that language needs to be included in there, along with with the exclusions and such. All right, in that matter.
Can I make one request? Do you mind, because you do have an idea of the language that I'm trying to come up with, possibly providing just. Thank you so much. And Senator, I will be glad to.
And then once we get that, send it through LSA and through my office, and then we will propagate that to everybody for review. And then 10 days after that, we'll get some more feedback. And then in 30 days, we'll come together and hopefully have a bill. Does that sound reasonable?
Senator, can I ask for clarification on that?
Absolutely not. Certainly, Trace, go ahead.
On that bill, are you wanting all the language? I heard you say both sole and to the extent. Are you wanting both of those in?
In the first draft, yeah, I want to have all the language in that people have talked about. All right, because I want to have everybody to see everything that's being discussed and what may or may not be controversial. I want everyone to see what everyone else is trying to convey and talk about. All right, and
Do you mean that you're asking to see these bills again, that it goes out to everybody, or would you like us to break down the language? Because some of these are going to be like you would just the facts, and I think they're going to remain the same regardless of the piece of legislation.
I want to be put in as in an understandable form as possible. Okay, with whatever system you may want to put in. Footnotes, color codes, I don't care, all right? But make sure that everyone will be able to see what the changes are and what the controversy may be. I think most of us understand all that, okay? But don't take anything for granted. That I hope to have in the first supposed draft. 10 days, then I want to send that out to everybody. That's where the bloodletting may occur. And then we'll find out where we have a consensus or not. And then at that time frame, we can find out at least in 20 days whether we're going to get close or not, whether we're going to have something or not. And then we'll find out who is the sacrificial lamb. Okay? And then from there, we'll proceed and go, hopefully draw it to a conclusion. Does that make sense? I see folks laughing. I don't know. John, did you have a comment? Sure, that'd be fine with me. So what's today's date? The 8th, right? Okay. The 22nd would be fine with me.
And Senator, are you asking that we will reply to this in the same manner that we have with the meetings with everybody on it, or are you wanting them to send everything to me directly?
You be.
Okay, I
I
appreciate
thought I
it.
heard the volunteer.
Absolutely, I did.
Okay.
Yeah. I did.
Okay.
Yeah, I may miss a word or two in there, but yeah.
So, yeah, if you don't mind.
I do not mind.
Take that on, let everyone get to Campbell, and then you be the responsible party for getting that to the LSA and to me, and then we can take a look, and then we can shoot, maybe we can adjust or whatever from there. Whatever we need to do.
Okay.
And if there's a question, we can deal with that. Then we'll get all of that to everybody
Okay.
for further review and discussion. And then, what's the next date? How about October 10th? That's more than 10 days. But so is the 22nd. And then, yeah, I think that you work on weekends. And then we can meet together, I don't know, 17th or 18th, something along that line of October. I'll let the true Diane select that date and submit that out. Is that all right? Correct. That be all right with everybody? Okay. Any other discussion or questions? Anthony, have I left anything out? A change. I don't hear that much. Yes, sir.
Question for David. Trent Davis represent University of South Alabama, and from an owner's perspective, is there anything about this bill that'll affect the owner's contract with the contractor?
The way the bill's written now, the way that what you've seen is different than what we've discussed and where we're going to. I believe as what we've kind of agreed to in theory, now it will not have an impact. Yes, that would on the owner from the standpoint is that the way that the bill's written, the owner would not be able to require a general contractor or those below them to indemnify and to go ahead and defend another for the owner's own negligence. So while you could ask for the general contractor to go ahead and provide insurance and everything else, which may or may not, they still would. Nobody upstream, downstream will be responsible for somebody else's negligence in the way that that's written. It would protect the general contractor. If you were to do, so if you have somebody, you are the owner, and the general contractor is not on site, it just happens to be there's a job there and you have a rape or you have somebody get injured on a scooter there, you would not be able to go after the general contractor for any negligence that might be alleged to the owner, maybe not keeping safe place, not keeping a safe environment, or knowing that there is an individual out there who's a sexual predator, things of that nature you would not be able to require the GC to do that.
Could to the extent you require the GC to have insurance.
Correct. Correct.
If this includes the public entities, the solution for the public entities is to make sure you require your GC to give you insurance.
Right. And Oscar, and that's why I was making the clarification from the bill that he's looking at to what we've agreed to. And that's why I said, from what we've agreed to in theory, no, you'll be fine.
I think Mr. Campbell said that he'd welcome any language you have to include in that.
Well, I bring that up. We use the Department of Construction Management contracts. I'm sure you guys are familiar with those guys, and so I tried to get them invited to this meeting, but they didn't respond back to me. But okay. Anyway, I don't know if I haven't heard y'all's opinion on this subject at all, so I don't know.
Will you have some language also? Okay. Final note, make sure everyone has good emails, good phone contacts to David and to LSA for us, okay? And we'll get this nailed down. I'm more optimistic than I was earlier today. Any other comments or questions? Any objection to adjourning? We stand adjourned. Thank you, gentlemen, ladies.